Guests, dear colleagues, it's my pleasure to welcome you all at this conference. I'd just like to briefly introduce you our university's activities related to online platforms and then raise some preliminary questions. And I expect our distinguished speakers to answer these questions in the forthcoming presentations today and tomorrow. University of Public Services activities are tightly connected to online platforms, and we have two research institutions dedicated to the research of this topic. One of these research institutions is the organizer of this event. It is the Institute of the Information Society, but we also have a cybersecurity research institution. These colleagues who work for these institutions are mainly deal with research activities. But we're also involved in teaching. We have a Department of Social Communications. That's quite a recent invention, the 2-year-old department, and it also make research and teaching that is related to the issue of today's conference. And we also publish books, and we even have a scientific journal. You can see the cover on this slide. And if COVID allows that, we also try to organize some events related to media regulation, media law, platform regulation, and general issues of online platforms. So my preliminary questions are, I don't want to elaborate on the influence of online gatekeepers and social media platforms generally on freedom of expression and the public sphere. That is a truism, that the effect of these services is just enormous. And a unique feature of these services are that they have the private power to restrict users' freedom of expression. Usually, we are afraid of government and states generally. They have the power to restrict freedom of expression and media freedom. These are the days when private power is getting more and more dangerous. Sometimes it seems as dangerous as government power. Social media platforms have the power to filter, delete, and block user content, as we all know. That is a visible effect. A less visible effect is the decision on what content is available, or at least easily available for the public or for the individual user. That is similar to the editing process of legacy media. The basis of these powers is the European regulation titled ECommerce Directive. It's a 21-year-old piece of legislation. It's fairly old. Social media platforms did not exist at that time, but they are still valid law, and obviously our national regulations are in line with this European directive. According to the directive, platforms, they are called hosting providers in the text of the directive, may not be subject to any general monitoring obligation, but they have duties as well. They are required to remove any violating content only after they become aware of its infringing nature. This is what we call the notice and takedown procedure. And this one is in some aspects a problematic feature of the European regulation, because this provision enforces platforms to make decisions upon the legality or the infringing nature of a certain user content. So now we arrive to problem number one, which I want to raise today. State regulation or EU regulation forces the platforms into a decision-making role on user speech, on freedom of expression generally. And this procedure in the directive and in national legislations generally lack the constitutional guarantees of freedom of expression. That is what makes this provision even more problematic. On the other hand, governments realize that courts and media authorities cannot handle these problems in the general procedural ways they have, and so governments generally all around Europe expect cracking down on illegal and harmful speech from platforms. Harmful meaning unlawful and not necessarily unlawful speech. So we talk a lot about hateful speech that is not hate speech in the legal sense, or fake news, which cannot be banned according to freedom of expression principles, but still these platforms are expected to step up against such users' content, and that is problematic from a free speech perspective. Let us make a short detour to the United States. All our colleagues are familiar with this 25-year-old legislation, the Section 230 of the Communications Decency Act, which allows freedom to online platforms. Basically, it provides immunity for platforms with respect to illegal third-party content, so no notice and takedown procedure is available in the US. Platforms don't have any duty to step up against illegal content. We have some exceptions for that, but they are very limited. And on the other hand, the law protects the Good Samaritan blocking of offensive material, so platforms, as they are in Europe as well, are free to block, filter, and delete user material if they find it offensive, which obviously not the same as illegality. Problem number 2 is private regulation. Platforms may enforce private regulation of the user's content through their contracts, or user sign or at least agree in a contract with the platform. I always ask my students in a class, they're all Facebook users, they are all users of several platforms. I can't even recall their names. And I always ask them whether they ever read the contract they signed with Facebook or Twitter or YouTube or any other online platforms, and so far no one raised his or her hand. So basically no one knows what the contract, what the content or the provisions of the contract are, which doesn't change its binding force, obviously. Codes and standards set up by these platforms can have a binding force through the contract with the parties or the users, but obviously these codes do not observe any constitutional free speech guarantees. So that is what we call private regulation, the private power to regulate speech parallel to the legal system. There's a very interesting invention by Facebook that is called the Oversight Board. I consider this new institution as being part of private regulation, because this decision made by the Oversight Board can restrict user speech just as a moderator can do. Though protection from dangerous or harmful content may seem necessary from a governmental perspective as well, it can collide with free speech doctrines and free speech practice. So that is problem number 2. We have some recent legislations and proposals for social media regulation all around Europe and even in the US. We are familiar with the German and the Austrian regulation and the French. The French regulation was declared as unconstitutional by the Conseil Constitutionnel, but the general idea behind the French regulation is more or less the same as in Germany or in Austria. They are not there to protect user speech, they are there to enforce the platforms to delete illegal content as quickly as they can, so in 1 hour, 1 day, maybe 1 week. and thereby the provisions, the legislation reinforces the need for deletion and further strengthening the legitimacy of the private regulation of the platforms. We have very interesting legislations from Florida, the Florida law this year. It was established and then tagged in the court. The court decided that the Florida law is violating First Amendment jurisprudence and contradicts federal law as well. The Florida law tried to regulate how social media companies can moderate content, especially speech made by public officials and politicians, thereby restricting the scope of private regulation. We also have a very interesting proposal from Poland, also aiming to restrict these private powers by the platforms. The Polish proposal says that only those contents which are against the Polish legal system, so they are not protected in Poland according to free speech doctrines and practice. These are the contents that can be deleted, and private regulation is basically banned according to this proposal. I don't know what will happen with the proposal. My personal opinion is that presumably a similar type of law would be unenforceable, first of all, for jurisdictional reasons. We have the Digital Services Act proposal from Brussels in the European Union, and we have the UK's Online Safety Bill. We will hear much more about the latter one. These laws, these proposals aim to strengthen or just establish certain guarantees for the protection of user speech. So all countries and all supranational institutions try to deal with these problems somehow. There is a theoretical solution to the problem, that is the application of the public forum doctrine. According to the public forum doctrine, it comes from the US, but not completely foreign to Europeans either. According to the public forum doctrine, people are free to use public forums, streets, parks, public squares. They can speak there, they can gather together there without unjustified or unconstitutional limitations. If social media platforms are considered to be public forums or fora, it would open the gates to the restriction of the private regulation and the restrictions on their operation. But according to US case law, and to a lesser extent, European case law, at this moment it doesn't seem very likely that in the near future social media platforms will be considered as public forums. Theoretical solution number 2 is the German way. Civil law is getting more and more important in the case of online platform regulation, which is an interesting new development. The horizontal effect of fundamental rights, it's a very interesting and traditional idea behind German private law. That is basically the possible application of public law rules or constitutional law rules in legal relations between private individuals. That is the Drittwirkung in German. So if freedom of expression is something that is important in a private law contract, that would open the gate to restrict private power as well. Applying the constitutional freedom of expression doctrines to contractual relationships, this is called digital constitutionality, and we will hear elaborate view on this idea today. Problem number 3 is the curation of content, which is a problem that is less visible than deletion or blocking. Up-ranking, down-ranking, prioritization, we can call it different ways, have been under less scrutiny. But basically, content moderation, that is deletion of a certain piece of user content, and curation are two sides of the same coin. So they both restrict, they both limit freedom of expression, and they both determine what content is easily available for users. The provision of personalized services can reduce the diversity. Diversity is very important in Europe, diversity and pluralism of content, and the curation by the platforms goes against this generally acknowledged value. Also, the personalization of news goes against the concept of marketplace of ideas. To name a US idea, users do not necessarily meet opinions that contradict their own opinions. We can call it the filter bubble or several other names we can use. But the idea behind, the problem behind this practice is that the platforms determine what is available, or at least what is easily available for users. The media regulation toolbox is it's a very traditional provisions that are in force from the 70s or the 80s in Western European countries. So when state regulation aims to widen or protect media pluralism, it can use several different tools for reaching this aim: ownership concentration rules, right of reply rules, impartial news coverage provisions for broadcasters, must-carry rules for media distributors, and several others. Obviously, these rules are not directly applicable to social media platforms, and we cannot think about the situation when these will be applicable in their current form, but at least we can think about of the future role of these rules in the age of online platforms. So the future of the regulation is uncertain, to say the least, but we have some ideas what will happen in the future, in the forthcoming years, what is ahead of us. That is for sure that the judicial system or public authorities, media authorities, will not be able to handle the workload associated with the operation of platforms. So they cannot make decisions on users' content on a daily basis. This leads to the conclusion that the notice and takedown system remains the basis for the liability in the foreseeable future. The European Union's proposal and some other ideas at the national level aim to strengthen users' freedom of expression, mainly through appropriate procedural guarantees and the creation of the independent forum for review or for redress. The contract between a platform and its users provide an opportunity to take the interests of users more into account, so that is a possible direction. And the media regulation solutions, a toolbox widely used in Europe, can at least inspire the regulation of platforms. For example, the introduction of right of reply to social media platforms is not something that is unthinkable at the moment. We are very far from that. But obviously, this was just a quick introduction and the raising of some important issues. There are many more timely and complex issues to be discussed today's and tomorrow's event. So thank you very much for being here. Welcome everyone, and have thoughtful discussions. Enjoy your time in Budapest. Thank you.